The China Stone Coal Mine project was subject to approvals under both the Commonwealth Environment Protection and Biodiversity Conservation Act of 1999, or the EPBC Act, and various pieces of Queensland environmental legislation. Given that the proposed mine was solely located in central Queensland, the questions I would like to explain are: what rights has the Commonwealth Government got to make environmental law? Does Queensland environmental legislation apply? And why is also required under the Commonwealth EPBC Act? When the Australian Constitution was drafted and came into effect on the 1st of January 1901, the environment was not considered and is not directly referenced in the Constitution. Under the Constitution, the powers for the Commonwealth to make laws for the peace, order and good government of the Commonwealth are set out in Section 51. There are a total of 39 powers under Section 51, which allows the Commonwealth to legislate. Although there is no direct or explicit power in Section 51 to make laws for the environment, some of the powers under Section 51 have been used as the basis for making environmental legislation, and some of these include Section 51(1), Trade and Commerce, Section 51(20), Trade in Financial and Foreign Corporations, and Section 51(29), External Affairs. Many of these powers have been tested in court cases, and an example is when the Commonwealth Government used the External Affairs power under Section 51(29) to stop the Franklin River Dam, which had been approved by the Tasmanian Government. The basis for the Commonwealth Government to stop the project was Australia's international obligations under the World Heritage Convention. Under the Australian Constitution, states have the power to make laws within their boundaries, and this includes environmental legislation. In this project, a range of Queensland environmental legislation applied, which included the State Development Public Works Organisation Act of 1971, the Environment Protection Act of 1994, and the Queensland Mineral Resources Act of 1989, to name just a few. The final point I would like to make is, now that we know the Commonwealth has the power to make environmental law, and Queensland environmental law also applies, why does the EPBC Act also have to be applied to this project? Under the Commonwealth EPBC Act, the mine site is classified as an action, and it was also determined to be a controlled action for the project. What this means is that the project had been assessed as having a likely significant impact on a matter of national environmental significance, an MNES. There are currently 9 MNESs listed under the EPBC Act, and in this project 3 of these were triggered, and therefore the EPBC Act applied to this project. In summary, therefore, proposed project was subject to both the EPBC Act for the Commonwealth and Queensland environmental legislation. Thank you.